Hello, my name is Gethin Rees and I'm a lecturer in sociology at Newcastle University, the one in the UK. And it's an absolute honour and a privilege to be here speaking with you today, albeit virtually, with this keynote to the Sexual Violence Medicine and Psychiatry Symposium. For those of you who are maybe not familiar with my work, I'm a sociologist of science technology studies, medical sociology, with a keen interest in the intersection and interrelationship between healthcare professionals and criminal justice when healthcare professionals become involved with criminal justice. And one of the key projects that I'm probably best known for is my work on the post-sexual assault forensic intervention, and I've, through a range of projects, investigated the work of doctors and nurses in both England and Wales, Scotland and Ontario on the delivery and performance of the forensic intervention. As well as that, though, I've also looked at the introduction and embedding of nurses within police custody environments in England and Wales, and related to the paper that I'm speaking to today, have investigated the case study of the alcohol-induced sleepwalking defense and how forensic medicine was able to provide evidence over whether somebody was sleepwalking or potentially sleepwalking when they committed a criminal offence. So this latter topic is what I'm going to be focusing on today. The paper is a work that this particular paper is I've co-authored with Professor Deborah White from Trent University, Ontario, and Deborah, and it's based around a trial, the trial of R.V. Hartman, which ran between 2017 and 2019, which was in Ontario. And Deborah identified the trial as a case where the alcohol-induced sleepwalking defense was being run as a defense. And when we looked more deeply into the case itself and the trial itself, we noticed that the expertise of the expert witness, the sleep expert being investigated or presenting evidence, was quite easily deconstructed, and he's quite a well-known expert. And the question became, why was it so easy to deconstruct his expertise in this context? And this led us on to discussions of marginalisation and the role of the alcohol-induced sleepwalking controversy, something that I had been following for a number of years leading up to Deborah making me aware of this trial, the role that this controversy played in his testimony in particular. So what I'm going to focus on today, again, noting Deborah's very much involvement in the development of this work, but I'm going to present on the way post-controversy knowledge resulted in marginalisation in the courtroom. So very briefly, to give you an overarching view of the paper, we'll start with some very brief comments on the literature on marginalisation in science, then a very brief view of the alcohol-induced sleepwalking controversy. I could quite easily spend all of today discussing the ins and outs of the controversy, but I think locating this and using it as context as for understanding a particular trial and the role of expertise and the way that expertise played out in that trial is potentially more interesting. So I'm going to spend the latter half of this paper focusing on the case of R.V. Hartman, giving you the details of the case and the ways that the sleep expert Colin Shapiro had his credibility set up and then deconstructed through that. So let's get on and start initially with some discussions about marginalized science. So those of you who are familiar with the history and sociology of science will know that scientific controversies play a substantial role in the methods of the disciplines. We look at how knowledge has progressed at the choice points taken at various points throughout history to decide what counts as true or correct knowledge. Controversies are those periods when choices are made. And since the work of Thomas Kuhn, it has been sort of discussed or made clear that those who are, we do not like the term losers. Deborah used to say that losers are the type of word Trump would use, but those who are not on the winning side, not on the side of controversies that result in the knowledge production, that they are never fully, it's not like their ideas or they themselves appreciate that they were wrong, that their interpretation of events or their interpretation of the data was inaccurate, or their decision to use a particular method was inappropriate. Rather, that they continue to hold these beliefs about their ideas or their interpretations or their methods until, as Kuhn kind of put it, they died out. And so knowledge has this sort of long tail of the so-called losers of controversies, who cling to what are seen to be misguided beliefs, and then the next generation of scientists who learn what constitutes as the new consensus about an idea, about a method or about a practice or about a particular knowledge claim, they go on. So the new knowledge that is resolved out of the controversy, the consensus that forms around the controversy, the new scientists learn that, and therefore that becomes almost the backbone of the discipline. And the question that was ever uncertain or contingent is forgotten. So these, rather than calling them the losers, we'll call them the marginalized from the rest of the scientific community, are never really dealt with. They are just pushed, like the word says, to the margins. Now, while this has been an interesting discussion within sociology of knowledge and history of science, it's only been quite recently that any kind of processual explanation has been provided to explain exactly how somebody who could be core to a scientific community, could be core to a scientific discipline, transitions from the core to the periphery, how they become marginalized. The way the literature has dealt with it up till then is to basically assume they lost the controversy and are then kind of ignored and written out of the history of the discipline. The work of Delbourne and later Wozek, and apologies for mispronunciation of any surnames here, but their work has really tried to explain the process by which marginalization takes place in science writ large. And so we have these series of steps. Some of these I've taken directly from Wozek, and some of these are just bringing together the work of Delbourne and Wozek myself. So step one, the first step, of course, is the closure of the controversy, the end of the controversy, with the consensus amongst the scientific community being to use a particular method or not use a particular method, or to interpret the data in a particular way or not interpret the data in a particular way. And as I said, this becomes the knowledge that is then disseminated to new students, to new members of the community, and becomes the sort of the backbone of knowledge. As I say, the marginalized do not accept this and continue trying to engage with the scientific community at large, publishing in, submitting articles to journals, submitting abstracts to conferences. So this is the period, the step two, agonistic engagement, where the increasingly marginalized tries to engage with the community, trying to explain why their claims and their arguments should still be listened to by the community. Now, the response to the community to these is, if it's an article, for instance, is to potentially publish it, but with a rejoinder explaining what the authors have misunderstood or got wrong. If it's a conference, maybe to ignore the abstract and not invite them to the conference. And similarly with a publication, to maybe ignore the publication altogether. So it becomes a point where the authors, the marginalized authors, marginalized scientists, are trying to engage in scientific debate, using scientific discourse to try and involve themselves to explain why they should be still listened to, but they are increasingly either corrected in disciplinary texts or ignored completely. This results in step 3, a sort of development of a defensive attitude. Why am I not being treated like my peers? Why is my work not being given the respect that my past work has, or my peers' work has? And over time of constantly submitting things, using the processes of agonistic engagement, but getting rejected or ignored, a shift takes place where the only explanation possible for the constantly being ignored or rejected is that, of course, there is a conspiracy against you. That you are absolutely right to say what you want to say, but there are procedures and processes taking place that you are unaware of that are stopping you from being able to say what you want to say. So editors are being told not to publish your work, etc. And so the marginalized moves from the scientific discourse of the agonistic engagement period to step 3, which is an increasingly defensive and even victim-based discourse that they are being worked against by Machiavellian hands in the community. This eventually leads to step 4, where they stop looking for engagement with the scientific community themselves and seek alternative allies in other fora. For instance, Delbourne writes about non-governmental organizations, and Wazek discusses anti-Semitic political groups. And here, of course, the discussion is no longer about the minutiae of the controversy itself, but rather broader questions about freedom of speech within scientific community. The fact, I suppose, that nowadays we would say they are being cancelled, and the discourse has transitioned from scientific discourse to particularly non-positivist discourse. So this is the discussion of marginalisation that serves very much as the sort of thematic tools that I want to explore when thinking about Colin Shapiro's expert evidence in the case of R.V. Hartman. But before going into that, I think we need a brief summary on the alcohol-induced sleepwalking controversy that took place and very much presented the context in which Shapiro's evidence was presented. So 2 important cases can be seen as the starter pistol of the alcohol-induced sleepwalking controversy. One of them, they're both English cases, it's important to know. One, R.V. Lowe, which was written up in Ibrahim et al. 2005, was a murder case. Just to give you the very brief summary of what happened in that case. Lowe, his father and his brother were all grieving after the recent death of Lowe's mother. And they spent the day drinking very heavily. As the day progressed, an argument began between Lowe's father and Lowe. And in order to try and reduce the tension, Lowe went to bed. Sometime afterwards, Lowe's father entered his bedroom, continuing the argument and shouting at him. At this point, Lowe got out of bed and proceeded to stab his father approximately 90 times. He had no recollection of the event. Similar case happened shortly after, this time a rape case, case of R.V. Bilton. Bilton was in York City Centre, socialising with friends. One of his, a female friend, became inebriated, and Bilton offered her a place to crash, a place to sleep. Bilton took the friend home. He put her into his bed, and Bilton went and slept on the sofa. In the morning, Bilton recalls hearing the front door slamming, which was the friend leaving. He is awoken. He's still on the sofa. He is awoken a couple of hours later by the sound of the police knocking on the door, who will then arrest him on a charge of rape. He again had no recollection of the event, but had a history of sleepwalking. And to sort of cut to the chase on this, that basically the accepted version of events is that he sleepwalked to his bedroom from the sofa, and then proceeded to rape the friend, and following returned to the bed. Returned to the sofa. So we've got two cases which were written up in the sleep medicine, forensic sleep, and the forensic medicine journals literature in 2005 and 2006. Both of these perpetrators were investigated by Irshad Ibrahim and Peter Fenwick, or Ibrahim and Fenwick as I'll refer to them, who are both reasonably eminent sleep experts. It's important to note that both were actually on different sides of the criminal trial, so working on for the prosecution or the defence. However, because of the rules of expert evidence in England and Wales, they were invited to produce a joint expert report. Upon reviewing the case files in Lowe, they decided that what was needed was a polysomnographic test of Lowe's sleeping, because they believed that it demonstrated an episode of parasomnia. Now, what is a parasomnia? So sleepwalking is probably the most well-known parasomnia, but there are many others, including sleep sex and sleep-related eating disorder and sleep driving. And so these are events that take place while one is asleep. Of course, if a criminal act is committed whilst one is asleep, then the accused is entitled to an automatism defence. They were not conscious at the time, they were not in control of their actions, and therefore they do not have the requisite mens rea, guilty mind, etc. So they're entitled to an automatism defence. In England and Wales, the automatism defence is split between the insane and non-insane automatism version. The insane is there is an internal cause, for instance, epilepsy or diabetes or something that has resulted in the automatism action. And really, this kind of relates to risk. It's the question of whether there is a likelihood, because of your condition, of this reoccurring in future. If there is, then you will be given an insane automatism defence. If it's the product of an external cause, for instance, a loud noise, something that's triggered something while you were sleeping, then the potential likelihood is it's not likely to reoccur in future, and therefore it's deemed to have an external cause and be a non-insane automatism. What's important about this is because, as I'll go on to discuss shortly, the insane, non-insane automatism, Ibrahim and Fenwick used as part of the justification for why the test is useful. So we'll discuss that in a moment. But because of this distinction, Ibrahim and Fenwick took the typical sleep medical test of polysomnography, which involves somebody's sleep being recorded via an EEG and an ECG and video monitoring, etc., and added an alcohol challenge night where the suspect consumed some alcohol before they went to bed to evaluate the effect, the impact that alcohol had on somebody's sleep architecture, and therefore to see if it is if they are more likely to be in a place where they are likely to have a parasomnia following consumption of alcohol, and therefore whether alcohol itself constitutes an external cause. So the case of Lowe and Bilton, they both had PSG investigations following, with alcohol challenge, following their criminal behaviours. So what was the results of the PSG investigations? Well, in the case of Lowe, there were no signs of any form of sleep disorder on the baseline night. But after the alcohol challenge night, and sorry, the baseline night is the night where people are getting used to sleeping in a sleep clinic, and so it's and getting used to the recording materials. It's sort of a baseline check of what somebody's sleep is like. But the following nights, when an alcohol challenge was enacted, they did notice an increased amount of arousals from slow wave sleep. Now, arousals from slow wave sleep is something that needs to be explained. So on the top right here, we have what a sort of typical chart of sleeping patterns. Actually, no, this is an atypical chart of somebody's sleeping patterns, and I'll explain why. You will see that at the beginning, there's stages of sleep 0, 1, 2, 3, 4. And that's the sort of normal patterns that we sleep through, from a lighter level of sleep, levels 1 and 2, to slow wave sleep, which is level 4. But the deeper in lay language, deeper sleep, levels 3 and 4. And you can see at the beginning of the night, this person transitions gently in this step-like fashion between stages 0 to 4. What is then meant to happen is that the person will then move stepwise, again, fashion between steps 4, 3, 2, 1 to eventually get into REM sleep. But what has happened in this case is this person has moved quite violently from step 4, from a deep level of sleep, to a lighter level of sleep. And this is indicated by the straight vertical line going up. And you can see that as a result of that, they've had a partial awakening with body movements. So that would be an arousal or a parasomnia. It's this arousal from slow wave sleep, from a deeper level of sleep to a lighter level of sleep. And this is what we understand is the cause of a parasomnia. So what they argued is that we could look at an increase in arousals from slow wave sleep as indicating that somebody is more likely to have a parasomnia. It's unlikely. It's not never. It's not. It's not rare, but it's unlikely that somebody, due to the very narrow period that somebody is having a clinical sleep investigation, that they will perform an act. And so Ibrahim and Fenwick were looking for indicators that mark the likelihood of somebody being affected by parasomnias. And so these arousals from slow wave sleep, specifically after alcohol challenge, were a good indicator for them. So in Lowe, Ibrahim and Fenwick argued that they agreed, that Lowe had a sleep disorder triggered by stress, sleep deprivation, and alcohol. In the case of Bilton, on the baseline night, he had evidence of sleep apnea, and therefore he already had disrupted sleep as a point due to his breathing. And then on the alcohol challenge night, similar to Lowe, there was an increase in arousals from slow wave sleep on following alcohol challenge, more so than they were on the baseline night. And they argued that this was consistent with sexsomnia. So the outcome in both cases is that Lowe and Bilton were both found not guilty due to automatism. In the Bilton case, Bilton was completely acquitted. The court decided not to engage with whether this was internal or external, sane or insane automatism. They just gave a complete acquittal. In the case of Lowe, they deemed it to be an insane automatism, that the parasomnia was an internal cause, and therefore he was sentenced to 12 months in a secure hospital. What these cases identified, however, was that the alcohol challenge tool, the addition of alcohol to the traditional PSG, would be useful for ascertaining whether alcohol constitutes a trigger for parasomnia. So as I say, Ibrahim published 2 papers outlining the case reports of Lowe and Bilton, and these triggered a substantial controversy in the sleep medical literature. In particular, the group of experts based around and centered around Dr. Mark Pressman, who was working in Minnesota at the time, were highly critical of the use of the alcohol challenge test and any claims that alcohol triggered a parasomnia. Pressman and colleagues entered a heated correspondence with Ibrahim and Fenwick between 2007 and 2013. The main points of Pressman's et al.'s critique were that, firstly, alcohol does not trigger parasomnias. They argued, so Ibrahim and Fenwick argued that slow wave sleep in intoxicated persons has higher frequency. So if you're intoxicated, you're going to have greater slow wave sleep. Therefore, there is greater potential for a trigger to create an arousal out of slow wave sleep. Pressman and co. argued the counter. They said that actually alcohol reduces the period of slow wave sleep and therefore reduces the opportunity for arousals and therefore for parasomnias. So they critiqued the fundamental principle on which the alcohol triggering mechanism was based. They also found there to be problems with arousals as being the measure for whether somebody was more or less likely to suffer with parasomnias, because arousals from slow wave sleep are not sensitive or specific enough to indicate a sleep disorder. For instance, those without parasomnias will also have arousals from slow wave sleep of an evening. And crucially, and this I think is a really important distinction that they drew out, is that forgotten activities after intoxication are not unconscious activities and therefore not automatisms. They said that these people are not entering into a sleep condition, but they are entering into an alcoholic blackout, that they are performing activities in an alcoholic blackout state, which they then forget, but at the level of brain activity, those activities are not unconscious activities, they are conscious activities, and therefore they do not fit the criteria of automatism. Interestingly, they take this further and say that culturally, if somebody has been intoxicated, then goes to bed, and then has a nocturnal wandering as a result of alcoholic blackout, we are more likely to label that sleepwalking when it in fact is not sleepwalking. It is nocturnal ambulation in an intoxicated state. And therefore, people get taken to see a sleep expert when in fact it's the alcohol that's causing the sleepwalk, is causing the ambulation, not necessarily sleepwalking. Ultimately, they argued that the alcohol challenge test was providing criminals with a defense that they were not entitled to. To defend their position, Ibrahim and Fenwick responded by saying that adding alcohol to the PSG was a sound scientific practice. In effect, it was the same as testing an expected diabetic with insulin. Would that have, let's say, what impact does insulin have on a potential diabetic, for instance, is the logic that they use to support the test. They said there's a long history of testing the impact of alcohol in sleep in both psychology and psychiatry, and therefore they didn't see why this was such a disruptive moment. And the two of the experts who were part of Pressman's group, Meyerwald and Schenk, had previously written in the late 90s about a forensic case where alcohol was seen to have played a major role in instigating the criminal offence, or the sleepwalking behaviour that resulted in a criminal offence. And therefore, in their view, it was generally accepted knowledge at the time that alcohol could constitute a trigger for parasomnias. And therefore, again, they did not consider what they were doing to be as disruptive or as controversial as Pressman and colleagues were making it out to be. They also argued that the expertise in England and Wales was very different to that in Minnesota and the rest of the United States. And in particular, as I mentioned earlier, the importance of the insane automatism, or the internal-external divide, requires some form of test to enable the court to begin to discern whether somebody's automatism was an internal or external, sane or insane. And so the test was serving a particular function within the English court. So this debate continued between 2007 and 2013 without any typical controversy studies, as is familiar to any controversy studies person, without any crucial evidence or any decisive intervention until about late 2013. Towards the end of the dataset period, we start to see signs of larger collectives and larger networks building behind Pressman. His letters and publications start to have more authors attached to them. For instance, their 2013 letter to the editor of Brain included 7 co-signatories from Australia, Canada, United Kingdom, and the United States. And of course, this international dimension is important, given what I just said about Ibrahim and Fenwick's criticism that the English legal system was different to the US. But with this larger group, who were all willing to challenge Ibrahim and Fenwick's work, they also clearly articulated the generally accepted scientific position on the relationship between alcohol, sleep, and sleepwalking is that there are no compelling scientific research data that support the notion that a reasonable amount of alcohol will either prime or trigger such a mixture of states as sleepwalking or sleep sex. And this statement was very important because this was to be the statement that would go on, that would in future go ahead and be the premise or the basis for the updates to 2 diagnostic manuals that are crucially important to sleep medicine. So one being the DSM. So this was at the time that the DSM was being updated to the DSM-5. And so there was an update there on parasomnias to include a similar statement, and the International Classification of Sleep Disorders, 3rd edition. So the ICSD 3rd edition, for example, published in 2014, now said, there is no scientific evidence that complex behaviors occurring during the sleep period following alcohol ingestion are anything other than nocturnal wandering of an alcohol-intoxicated individual. Unconsciousness, intoxication, and sleep are very different states of consciousness. Parasomnias should be easily distinguished from alcohol intoxication by the presence of significant alcohol prior to bedtime. So the point of the ICSD and the statement being made in the ICSD is that alcohol does not trigger sleepwalking behaviors or parasomnia behaviors. In fact, there's less likelihood of parasomnias taking place in the context of alcohol, and therefore we should not be diagnosing sleepwalking in the presence of alcohol. These were, of course, the positions articulated by Pressman and co. In the debates with Ibrahim and Fenwick. And so the consensus statement that we find in the diagnostic manuals are the positions not of Ibrahim and Fenwick, but those of Pressman and colleagues. Again, I reiterate, there was no clear decisive blow, no clear study that put an end to the debate. They published their position in the DSM and the ICSD, and that put them in a strong position to be declared and identified as the victors. And as you will go on to see, it had these documents had a major role in the case that we're about to discuss. It should be mentioned that the publication of these 2 updates did not go unnoticed and were deemed highly concerning to members of the sleep medicine community. For instance, Rosalind Cartwright, another sleep expert, argued that the Parasomnia Working Group of the ICSD-3 had no member from another country, and 3 of the members frequently published together. This homogeneity is, I believe, responsible for the one-sided premature conclusion that excludes all alcohol-related arousals from being given an NREM parasomnia diagnosis in the absence of any hypothesis testing studies supporting the decision. As we will go on to see, this potential conspiracy discourse, as I will come on to describe it, plays out in the trial of R.V. Hartman, which I will now turn to. So, just to give you a bit of context, Deborah and I took the decision, the judge's decision in R.V. Hartman, and both independently read it and coded it for sets of themes, and then discussed and reviewed the themes. And it's this decision where Judge Kimberly Moore, across 60 pages, explains the decision she took in the trial that we take as our data set. That's our evidence. So, the case of Hartman. Hartman's case was a rape case. It was a retrial following an appeal in which the appeal was at the appeal of a previous trial. The sexsomnia defense, or the sleepwalking defense, was introduced. The outcome of that appeal was that the trial should be rerun, and this trial that we have here, based around the sleepwalking defense, is the outcome of that appeal. So this rape trial arranged to assess whether Hartman was not criminally responsible due to mental disorder. It's important to note that the internal, external, insane, non-insane automatism distinctions do not play out in Ontario, are not part of Ontario law, and therefore those do not matter so much. It is straightforward: was this person potentially sleepwalking? So Hartman was at a party. He drank heavily, approximately 21 alcoholic drinks in the course of an evening, and fell asleep on an armchair. At some point during the night, he transitioned from the armchair on over to an air mattress, which was occupied by the victim survivor and her partner. So this was an air mattress that was on the floor in this party, where everyone had crashed out and gone to sleep, right? So Hartman is now lying next to the victim survivor. He then proceeds to anally rape her, and when she becomes aware of this, she screams and manages to remove herself away, waking up the rest of the people in the room around her. At this point, Hartman apologized to the partner of the victim survivor for making out with his girlfriend, as he put it. As mentioned, this case was all about whether he was sleepwalking or having a parasomnia, sexsomnia episode when he committed the sexual violation. He based his defense on both technical, expert, and family histories. So on the family histories, his mother had a history of sleepwalking. He also had a history of sleepwalking in his own youth, and his fiancée had observed him performing masturbation while he was asleep. As well as the family history, there were the technical expert examinations. So he underwent PSG in Colin Shapiro's sleep medicine clinic, where again, during the clinical investigations, he recorded a 4 to 5 second episode of sleep masturbation, which was recorded. On the alcohol challenge night, I should say that Shapiro is very close to Ibrahim. They've worked together, published together as well. So he ran an alcohol challenge night, and in the alcohol challenge, it was noted an increase in arousals from slow wave sleep, as well as an episode of bedwetting that Shapiro labeled as a parasomnia. As I will go on to show, that while the familial histories and medical histories were a part of the narrative Hartman was trying to bring, it was Shapiro's expertise that was core, and Shapiro's report that was the key to Hartman's defense. And so we turn to how was Shapiro accepted in the court. And if we look at Moore's decision, she begins very positively. Some of the markers of expertise that we know are considered to be markers of credibility, indicators of credibility, were very much in show on the trial. She says that, so this is Moore says that his expertise in psychiatry, neuropsychiatry, and sleep disorders, including parasomnia and sexual behaviors that occur in the context of sleep disorders. So he's an expert in the area. He's got a long list of relevant publications. He's got editorial positions. He's got membership of professional associations, directorships of sleep-related research clinics, and a history of testifying before courts. He has indicators of respectability and expertise. So why does Moore find Hartman guilty? So Deborah and I identified three factors or three themes that resulted in the deconstruction of Shapiro's credibility: clumsiness and procedural irregularities, assumptions and relevance, and a conspiracy discourse. And I'm going to take you through each of these three one by one. So let's start with clumsiness and procedural irregularity. As most experts do when they're constructing their credibility, he started by portraying himself as being procedurally accurate and relying on having significant mechanical expertise and also trained judgment. He knew exactly what it was to do this work correctly. So Moore puts it this way: in examination in chief, Shapiro explained that he carefully considered all of the available information and did not come to his conclusion based on one piece of information. In cross-examination, he advised the court that as a clinician, he does not simply accept what people say. There is a reason to question the veracity of the information. In cross-examination, he also confirmed that he looked at all of the evidence to support his opinion and considered whether there are other things that should be considered and excluded. He is rigorous. His work is rigorous. This is the position that he is trying to present in order to try and construct himself as a credible expert. However, under cross-examination, his standards did not appear as high as he presented them to be. He left out or was unclear about certain dates that he had met Hartman. It was unclear whether he had read some of the materials that were sent to him in the notes. Judge Moore puts it like this: he had also failed to record correctly the details of events, such as the dates of the meetings he had had with Ryan Hartman. Leaving Judge Moore to write, was Dr. Shapiro careless as to how he recorded that information? I do not know. Regardless of the reason for this significant discrepancy, I find it concerning. She also said, I find Dr. Shapiro's report very difficult to read and very incomplete. I find Dr. Shapiro's evidence that he may have merely skimmed over these notes from Hartman's previous lawyer in his review of the file concerning. I find it even more concerning that even when faced in court with these contents of these notes, he did not see that there were contradictions. And so his work, as he tried to present it as rigorous and thorough, through the court trial, we find that he's actually a bit sloppy, and it's unclear what he had and had not engaged with. The second theme we drew attention to was questions of assumptions and relevance. Now, a key part of the sleepwalking, of diagnostic criteria for sleepwalking or parasomnia is confusion upon awakening. And so somebody who is in a parasomniac state will awake and be very confused. Now, Shapiro thought this was probably the reason for the confession, for making out with your girl point from Hartman. He said that if, with the screaming of the survivor and everybody waking up and accusing him, he would have been trying to piece the story together, and ended up making the confessional statement. However, the problem with what he was saying was that in order to make this statement, he constructed his own opinion of what was the normal behavior of rapists. Put it this way, there clearly is the possibility that Hartman is guilty. And the reason that he's in court, so Shapiro put it this way, sorry, there clearly is the possibility that Hartman is guilty. And the reason that he's in court is that it could have been some sexual assault. The point that I think makes this much less likely is that he was very quick to say to the person who accuses him, then boyfriend, who was in bed at the same time, I think I was making out with your girlfriend. People who commit rape don't volunteer themselves as having done something which has huge consequences. I think there was a lot of other factors at play as well. He's trying to say this could be the response of being in a confusional state following a sleepwalking event. However, by drawing on the narrative of the normal behavior of rapists, he's really problematizing his own credibility and going way beyond his own expertise. Judge Moore noted that his generalizations made about how rape victims and sexual offenders would behave caused her concern. Another set of decisions that Shapiro made that Judge Moore found problematic related to the questions of relevance of the information of Hartman moving from the armchair to the air mattress. As we saw earlier, sleep is full of stages, and one traverses from stage 1, 2, 3, 4, 3, 2, 1, etc. in normal cases. And in fact, it's not always that we get as low as 4. We may go stages 1, 2, then 1, or 1, 2, 3, and then 2, etc. Okay, and Shapiro made this clear in relation to what happens. If you were fully awake, it would take a while to go back to sleep, and you don't immediately go back into deep sleep. You go into light sleep, and then medium sleep, and then back into light sleep, and maybe more medium sleep, and then you might get into a deep sleep. So this causes problems for Hartman's claim that he walked from the armchair to the bed, right? Because if he's awake and he's transferring, then he doesn't necessarily get back into a deep sleep to require that is required of for a parasomnia to take place. And again, this came out in a discussion between the defense lawyer and Shapiro. So the defense lawyer said, would you have paid greater attention to it, i.e. waking up and moving around, if when he had the kink in the neck, he got up and walked around? Would that have been more important? Then Shapiro says, then I would say he was awake. And it certainly would be relevant. And the likelihood of him going immediately back into deep sleep is less likely. Therefore, the question of Hartman moving from the armchair to the air mattress should be important. However, when he's discussing this with the prosecution lawyer, he has a very different take on things. So the prosecution lawyer says, when he woke up with a kink in his neck, why would you ignore that piece of evidence? It didn't seem salient to me. So because it didn't serve your purpose? No. Why does it not seem salient? If he said he dreamt about Batman in the middle of the night before, I might record that he dreamt about Batman, but I wouldn't think it's very important in the general scheme of things. The fact that he had arousals during his sleep, that is relevant. This is a really interesting quotation. I mean, the point and I will come back to this again towards the end of the paper, is that he's really prioritizing the technical evidence of the PSG here over the inferential evidence of the way somebody's sleep transitions. And he says that the question of whether or not waking up and then transitioning into a deep sleep state is not a relevant question for him to address. The fact that there is a well-evidenced situation where we see arousals from sleep, technically recorded arousals from sleep following intoxication, is the relevant point. The third theme that we draw attention to is his conspiracy discourse. And this is found throughout Judge Moore's report. She makes various mentions to the way he discusses Pressman throughout the trial. So Pressman is introduced into the trial by the prosecution. He is not actually involved in the trial, but he had written a report for the previous appeal trial, again reiterating that he did not feel that Hartman was sleeping, in line with his own positions around the alcohol-induced sleepwalking defense. So the following asking if Shapiro had read Pressman's report, the prosecution then asks Shapiro the following. The alcohol issue is, in your expertise, you believe it's a trigger to parasomnia. Is that correct? Shapiro says, yes, there's no question that it is a trigger to parasomnia. The difficulty is the DSM-5 says no. Do you know who wrote the DSM-5 section on that? Well, is it not the Bible that people follow? But if you go to the DSM-4, which was the previous Bible, no, there's a new religion. So we have this discussion throughout, as I said, throughout Moore's report, of Shapiro commenting on Pressman. I've just picked out a couple of key points here that make the argument for us. But so he says, Pressman was very instrumental. He was the chair of that section. He has a particular view, which is a minority view, and he's a very forceful individual. So he has promulgated that view, and it now appears in DSM-5. My own view, and the view of a lot of Canadian experts, is that he has hoodwinked the DSM committee. Later on, when the prosecution is reading out from the International Classification of Sleep Disorders, the prosecution says the following. Parasomnia core group was chaired by Michael Kramer-Bornemann and included members Carlos Schneck, Mark Pressman and Gerald Rosen. The process was quite comprehensive as follows. Shapiro then interrupts. Can I stop you there for a second? So I just want to point out that in terms of a pattern, Bornemann, Schneck, Schenk and Pressman have co-authored papers. So if there are 4 people on that committee, you know what is striking is that there's a number of people who have an opinion that they know is at variance with the opinion that they held, and it's an important issue. Not one of those people, like Ibrahim from the UK, were on those committees. That's fine. I don't need to be on a committee, but I'm just saying that it is a rigged jury, if you like, before it starts. Shapiro presents Pressman as a manipulative master villain who has, commenced a conspiracy against people like himself, like Ibrahim, and others who do not fit with the consensus of alcohol as a trigger for sleep for parasomnias. And this narrative comes out multiple times throughout the presentation, throughout the testimony. And so we see this narrative, the third level of marginalisation that we see from Waszek coming out very strongly in the testimony. Unfortunately, many times he equates Pressman's involvement with the DSM when Pressman was not, in fact, a member of the committee for the DSM, and so he had to concede that in one trial in March 2018, he had to concede that some of his claims about Pressman were in fact inaccurate. Due to this, and quite broadly because of Shapiro's testimony in the trial, the defense asked Judge Moore to ignore Shapiro's comments on Pressman, to which Moore commented, "It is certainly to be expected that expert witnesses will take contrary positions to other experts. It is also expected that expert witnesses will be asked to comment on the findings of other experts. This is quite usual and acceptable. However, in this case, I find that Dr. Shapiro's comments directed towards Dr. Pressman were unsolicited, gratuitous, and non-responsive to the questions asked of him. Most importantly, his criticism of Dr. Pressman's role in the DSM-5 were completely unfounded and factually incorrect. I find that Dr. Shapiro was careless as to many of his comments about Dr. Pressman before this court, and that his comments demonstrated a lack of professionalism." It probably goes without saying, though I think I've already mentioned it already, that Judge Moore found against Hartman, and he was sentenced. He was found guilty. So this leads to the question: why was Shapiro so easily deconstructed? Shapiro is a highly experienced expert. I mean, all of the narrative at the beginning about all of his experiences show that he is a highly credible, highly professional practitioner. Why was he so? Why were his actions so easily deconstructed at this particular trial? And Deborah and I believe that marginalisation provides the key here to think through his testimony in this trial and his supposed advocacy. as Judge Moore said is what he was doing. Firstly, we see the victim discourse that I pointed out in the third theme is rife. He really is at that third stage of marginalisation where he is not allowed to speak in professional fora and therefore is responding in that defensive or victim attitude. He does not transfer to the fourth stage, though, interestingly, because he doesn't have to. His expertise still grant him, and his expertise, his reputation, his credibility, still grant him access to public fora, if not scientific fora. And so he gets into the courtroom. And it's at this point that when the prosecution give him the opportunity to talk about the alcohol-induced sleepwalking controversy, that he lets rip, that he explains his position with insignificant detail. And again, sometimes some of his evidence only makes sense when understood in the marginalisation position, because the debate about why, the discussion about why he ignored the transition from the armchair to the bed only makes sense when you understand what he is trying to do is supporting the whole edifice that the alcohol-induced sleepwalking controversy or the alcohol sleepwalking defense is based upon. It's solid sleep medicine medical knowledge about the transition of states that when one is in a sleep state. But to be able to say, but to emphasize the technical recording, to emphasize the arousals from slow wave sleep and the frequency of arousals from slow wave sleep are the key points that the alcohol-induced sleepwalking defense is based upon. And so to make those points and to emphasize the importance of those points, the relevance of those points, is not only to support Hartman's defense, but it's to support the whole framework that alcohol-induced sleepwalking as a potential defense is based on. Judge Moore, of course, read Shapiro completely differently. She in fact took and reinterpreted and made her own scientific claims around the recording, the short 4 to 5 seconds of sleep masturbation, claiming that was a substantially different experience and activity from a sexual assault. She saw Shapiro's procedural inaccuracies and claims around typical rapist behavior as outside his expertise. And in the absence of any counter expertise, any alternative experts, she agreed with the prosecution's reliance on diagnostic manuals. The importance of the DSM-5 and the ICSD-3 were made clear throughout the trial. Not only did they provide an authoritative counterpoint to the argument that Shapiro was presenting, the discussion of those diagnostic manuals were what instigated his marginalisation and victimised discourse. While the texts are still controversial within sleep medicine itself, within the context of the trial, distance lends enchantment, and they seemed far more authoritative than they were in sleep medicine itself. Just want to spend a few minutes towards this end thinking about what the import of this controversy in this case is for our studies of sexual violence, which we are here to discuss. Without a doubt, sleepwalking defences are on the rise in sexual violence cases, specifically in cases where it's child sexual assault, where consent is not an issue, or where there is very little scope for alternative defences, then sleepwalking becomes a potential defence strategy. While the changes to the DSM and the ICSD have made it slightly more difficult in the context of intoxication to try and push a sleepwalking defence strategy, it's still a pretty low bar of entry. It's still pretty straightforward given what we know about arousals from slow wave sleep and the general way that most of us probably have a few can be involved, can have a reasonable attempt at pursuing a alcohol-induced sleepwalking defense. It's also the case that whether it might also not be needed in future, because as we saw in Ontario last year, automatism itself is changing, and so Ontario are looking at alcohol blackout as itself being an automatism, and which would be highly problematic and cause all kinds of problems, but wouldn't at least need the need for a sleepwalking defense, because alcohol blackout is sufficient enough to generate automatism. We may want to discuss that. I don't want to stigmatize those with the condition. I mean, there really is a condition called sexsomnia, and for those who, and the bed partners of those who have it, it is a significant problem. But the important thing to note there is they are very well known to clinical sleep medicine, and they have various therapeutic and sleep hygiene strategies for dealing with their episodes of parasomnia, including sexsomnia. The important thing to note here is that it's very, very rare for a criminal case to be the first case of sexsomnia that comes up in somebody's life. And as the sleep medicine community are right to say themselves, is that they should be very wary if the first time somebody appears with a sexsomnia case is in the forensic context. For I think overall what we can take from this case study is this broader question about marginalisation. And like science, like the history of science, where we begin to understand that scientists do not quickly give up their entrenched positions. They do not identify that their claims are wrong or their interpretations are problematic. They continue to hold on and as Kuhn would say, die out with their continued beliefs. And I think this is something we should think about in relation with the medical profession, and that their presumptions, their assumptions, particularly maybe about victims, survivors, perpetrators, etc., are things that are very difficult to challenge. And in our efforts to try and change attitudes and introduce interventions, we may come up against tensions and difficulties, because these beliefs, as problematic as they might appear to be, are long-standing and difficult to educate. So thanks very much for listening.